Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kayleigh Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. So thank you everyone for joining us today for Smart Strategies for Wealth Protection Estate Planning. I've got our guest with us, Darren Titmus from Financial Planning Queensland, and I am Kayleigh Swift, the Director of NB Property Law. So today we're going to take you through basically some strategies to help you with both your estate planning and some financial strategies as well. So a little bit about myself and NB Property Law. I'm, as I mentioned, the director here. So we're part of the No Borders Law Group. We've got 4 divisions. So the NB Employment Law, NB Migration Law, NB Property Law, and NB Commercial Law teams. Here at NB Property Law, though, we offer a personalised, proactive advice to help minimise the risk and take the stress out of your next property transaction or estate planning matter. We're more than just a team of legal experts. We're dedicated problem solvers committed to creating personalised solutions to guide you forward. From residential to commercial property law concerns, we're here to provide the clarity and guidance you need. Darren Titmus set up Financial Planning Queensland with business practices that would eliminate all of the above fears for any consumer. So in order for Darren to achieve his implementation of this, he's been able to basically ensure that he focuses on coaching his clients to help them improve their financial skills and their financial decision making. So he offers a fee for service advice only, which means that there are no commission arrangements designed to influence advice or product selection for his clients. So he uses superannuation investment funds. That means that clients basically pay nil commission for that. He also assists clients with providing a better position statement in plain, clear English, which is always important from a financial planner, provided in writing as to why and how the recommended strategies and any associated products used would benefit him over any of the current arrangements. So I'll hand over to you, Darren, if you want to cap off on introducing yourself, and then we can start talking about the first topic.
Hey, we're rolling now. Finally.
Welcome.
Okay, thank you, and welcome everybody. Yes, so look, thanks Kayleigh for the introduction. I started Financial Planning Queensland back in 2010, and as Kayleigh indicated, really it's strategic advice, fee for service only, but really we look for those opportunities that your typical mainstream planning firms are not looking for or not using to achieve your objectives. So to those ends, particularly when we're in single digit returns, we really want to optimise as much as we can around tax benefits and other issues, but also be looking ahead and seeing how we can best utilise clients' available funds for appropriate estate planning or early retirement and those sort of things. And they're the key issues that we're going to talk through today. And there's one particular investment strategy that is going to be highlighted today, but it doesn't mean that that's the be-all and end-all, and that's what we should do with 100% of our money by any means. But it's an opportunity for us just to highlight how estate planning and investment can work together. So that's the purpose really of Kayleigh and I working together on this today. So should we get into it? So we want to start by talking about generating tax-effective investment income, and really that can be fraught with danger, and there's a lot of history of serious issues when it comes to this. And the traditional methods often include deferred tax strategies, which is really just kicking the can down the road, and so that can be problematic. or lead to even greater tax bills down the track. There's the traditional agribusiness models that have also proved quite problematic, where we land with either no income or very little income. In a lot of cases, negative capital growth. Even though we've had some tax benefits, there's no point getting tax benefits if we're only making losses. And then the third key issue with tax effective investment is often that the money's locked away. We don't actually get access to our capital if our circumstances change or we need some money or those sort of things. So these are real issues that we need to be able to contend with. So can we have a tax effective investment structure and also produce a decent return on our investments year on year? And yes, we certainly can. And that's what we're going to talk about today. A structure that allows us to invest normally, whilst also having some tax benefits without all the other trade-offs that we've previously had in the past. Now, when we're thinking about investment or investing to reduce tax, a lot of people's mind instantly goes to, well, how do I reduce the amount of tax I'm currently paying from my employment income, or the amount of tax I'm paying from my business income? We're sort of thinking about tax savings today, upfront, immediately. It's very sort of short term, if you like. But I guess I challenge that way of thinking, in that if we can actually create an environment or create an investment where we can get ongoing tax benefits and they can go in perpetuity, the value of those benefits are going to be far greater than possibly a band-aid measure in the short term. And it takes a bit of a change of mindset, I guess, to think that through. And investment bonds are a way of actually doing that. Investment bonds are an investment vehicle that operate under the Life Insurance Act and the Tax Act, which means they're not subject to, for example, the handbrakes or handcuffs that superannuation rules apply. So they can be a lot more flexible. And investment bonds are a non-super investment that can also be structured as a non-estate asset. And that is very important for a lot of reasons, and we'll talk about the estate benefits a little bit later. But also it can provide a tax-effective structure on the inside to reduce the amount of tax that's actually being paid year on year within your investment. And we can get those normal investment taxes from 30% down to around 12 to 15%, which sort of brings it in line with superannuation taxes, if you like. Finally, with investment bonds, in terms of a bit of a snapshot at least, that we can generate very tax-effective income and very tax-effective access to capital, and very fast access to capital should we require it, all the way through the investment. So there's a little bit of a snapshot in terms of starting to invest with a tax-effective mindset and how we might do that, and how effectively investment bonds work. We can move to the next slide, maybe the one prior to that. Or have the slides changed?
I think this is the order of them, yeah.
Yeah, that's okay. We can move on. So investing under 50 now, and even investing under 40, really, because there are plenty of us, well, I'm no longer under 40, but there are plenty who, with a disposable income, who have the appetite for investing, but certainly don't want to be investing and not be able to have access to the money. And some of the challenges when we're investing young is, first of all, the need for future income. What's the purpose of the investment? Why are we really getting into this? And it can be especially challenging when we're young. If we're locking money away, we lose access or we lose control of the money, long waiting periods, preservation rules when it comes to superannuation, for example. If we look at investment properties, well, they generally involve taking on considerable debt. We might have particularly low net yields. We might have negative cash flow at a particular time, lumpy returns, and of course, there's the liquidity issue. And that doesn't mean investment properties are not right. They're probably just not right for 100% of our money. So definitely there's some issues there to consider. using managed accounts or direct equities, similar sorts of issues. With those, we solve the liquidity problem if we're using those vehicles. However, we're not really solving a tax problem. We tend to kick the can down the road a little bit with tax when it comes to those vehicles. Also, you can find yourself with a little bit of bracket creep on tax because the income is going to be accessible for you immediately within the tax year. And also, if you're a high income earner, you've got the Div 293 issues. So managing those sort of issues becomes pretty important. In terms of future income, if you've got 10 years or more through to retirement, we want to be able to generate tax effective income prior to that, right? So if we're 45, we don't want to be waiting till 60 to get some sort of tax-free or taxable income. And remember too, with super, you're only getting your tax-free income after age 60 if you've also retired. So the object of investing when we're young is to create some growth and income for our future, and the ability, if you like, to reduce working hours or retire early or those sorts of things. So a vehicle where we can generate that tax effective or tax-free income is really, really important. If we're using an investment bond, it works a couple of different ways. If we're holding that bond if we've held that bond for at least 10 years, it becomes what we call fully tax paid. Now, some people call it tax-free. It's not especially tax-free, but it is fully tax paid, which means there's no top-up tax when you take any money out, if you like. So you could turn on an income stream or you could make withdrawals after 10 years and there's no additional tax to be paid. In the event you want an income prior to those 10 years, prior to the 10-year anniversary of your investment, well then any earnings that you draw out of your investment, you get a 30% tax offset on those earnings. And that can be that's a very, very meaningful offset and can mean that those earnings may be tax-free. And in fact, we can show you a strategy where they do become tax-free even if you're in a higher marginal tax rate. And of course, there's no tax on the capital coming out. So those withdrawals or early income streams become very tax effective even before the 10 years is up. Now, one of the things we can do, which I'll talk about now with investment bonds, is that we can actually transfer ownership. And transferring ownership, particularly if you're under the age of 50, can be really, really beneficial. And when I'm talking about transferring ownership, I'm not talking about an in-specie transfer. I'm not talking about creating a stamp duty event or a CGT event. I'm simply talking about the transfer of ownership with none of those issues. And that would mean that if you're 45 years of age and you're married and you've got $300,000 in an investment bond and you want to take $100,000 out, well, we can actually transfer the ownership from the higher marginal tax rate owner to the lower marginal tax rate owner. So that lower marginal tax rate owner owns 100% of it. We can do the withdrawal at that point, get the 30% tax offset, and then if we wish, we can transfer the ownership back to the highest marginal tax rate owner. And all that without stamp duty, without CGT and the like. So that's a really beneficial strategy that can be used to help get early access to capital and incomes. The other thing when we're investing young is that there are often changes in circumstances. You may have another kid, you may have your first kid, you might buy another property, you might have an inheritance. There's lots of things that can happen under the age of 50 that doesn't necessarily happen as much when we're over the age of 50. So when we're investing, we want to be able to invest with confidence that, yes, we can invest now, but if I need the dough, if something changes in my life, I've got access to it. And that's really, really important. So the concept of the investment bonds allows to do that. And again, we're not sort of proponents of 100% of your dough should be in these structures. However, they certainly suit some people some of the time, and there's certainly some benefits that we're talking about. And then the last point I wanted to make in terms of investing young is how to increase our tax-free threshold. because $18,200, I don't know about you, but I just think that's way too low. So one of the things that we find with traditional investing is it can start to load up people's assessable income, and we end up with Div 293 issues and those sorts of things. So what can be a better plan? If we know we want to use a particular investment to generate income down the track, well, then the investment bond can be a good option for that. Because if we go back 5 or 10 minutes where we were talking about turning an income stream on from an investment bond, or making early withdrawals, or post 10 years having the fully tax paid income coming out, that is really, really beneficial, because that means that income is not adding to your taxable income at all. So you maintain your $18,200 tax-free threshold, but also any income coming from your investment bond is also effectively tax-free on your tax assessment. So whatever income you can draw out of that stacks onto your tax-free threshold. So if you've got $1 million in an investment bond after 10 years of putting money away, for example, well, then your effective tax-free threshold will go from about $18,000 up to possibly $80,000 to $100,000 per year in perpetuity. And that's really important even into retirement, for another number of reasons that we won't go into today. But that's a really, I guess, a strategic way of improving your tax-free threshold over time. Should we move on to what's next, Kayleigh?
Awesome. Thanks for that, Darren. So yeah, you've given us a bit of a snapshot, obviously, some strategies to build our wealth portfolio, and obviously the importance of doing so at a younger age rather than just waiting until we're near retirement. So I suppose in terms of having all this wealth built up and, you know, assets in your portfolio, it's obviously important to protect them from an estate planning point of view. So I suppose I'd first like to pose the question of who should actually have a will and why should you have a will in place. So essentially you become an adult from 18 years of age, and therefore that is the age you really should be looking to have a valid and legally binding will in place. To do so though, it can't just be anyone that has one. You do need to have the capacity to do so. So this means you are of sound mind, you have the memory and understanding to do so. In some situations we will ask for, you know, a doctor to confirm that the person has legal capacity, but generally, you know, we can kind of gauge whether that's needed or not from having a consultation with the client. It does not matter how small your estate is, it's still important to have a valid will in place. The possessions you own, the assets you own, the wealth you build up are important to you. You want to make sure that they go to who you wish for them to go to. A benefit of obviously having your will in place is it's going to minimize the stress for your family and friends. If you pass away, you've already dictated who you want to basically distribute your estate, which is known as the executor, and who that's going to go to, which are people known as the beneficiaries in your will. By having a will in place, it's also going to reduce the cost of actually administering the estate. So what I mean by administering the estate is applying for probate, and then once probate is granted, actually as the executor, looking at what the will says and administering it to the beneficiaries. Before we can take that step though, as the executor, they need to obviously compile and understand where all the assets are held and how they're owned, you know, banks, superannuation companies, investment bonds like Darren's spoken about. So they're probably going to have to get in touch with people like your accountant, your lawyer, your financial planner, you know, your superannuation fund, your bank, and sign the relevant forms to compile all that assets and wealth portfolio. And lastly, the one I'd like to speak about is actually by having a will in place, you're going to limit the likelihood of disputes that could arise if you don't have a will. So your will clearly dictates and outlines who you want to be the executor and who you want to actually benefit from it. If you are someone that's got children under the age of 18, it's going to include things such as guardianship provisions as well. So having this all legally documented will reduce the dispute that could arise. Obviously, disputes can always arise, but it just gives us more ground to stand on if it's actually written and signed off by the actual testator. So some examples I've included here is basically when you have separated. This is when your will, which you may have drafted, is not going to be legally binded. So if you've separated from your wife or husband or de facto partner, but were not divorced, and you did not have any children at the time of your death. So at the time of your death, you did not have a valid will. If your former wife will be entitled to your whole estate. And then if you did have a will, you would be able to actually dedicate who receives the estate. So that, like I said before, they're known as the beneficiaries. Now, what are the actual benefits then of having a will? So as I mentioned, it's going to preserve your assets. It's going to pass them potentially down the line, to your children, grandchildren, great-grandchildren, whoever it may be. Maybe you don't have any of those people. Maybe you want the money to go to a charity, or potentially, you've just got a good friend that it's going to all be passed to. But that's your choice, and you get to dictate who that's going to. Other options is, we can look to establish a trust to provide for your children, or a beneficiary who may have a disability. So often clients may come to us and, they've got a child who is of legal age, but they're still caring for them. And, unfortunately situations, may arise, they've become disabled, and they want to make sure that that trust set up will give them the money they need to care for them and look after them, well into their adulthood. The other benefit is that it will allow you to actually donate some money to a charity, as I mentioned earlier. So some people, obviously, they may still have children and other beneficiaries that are family or close friends they want to give to, but they also may want to give a portion of their estate to a charity. So we'll make sure that the correct wording is included so that money is going to the charity as directed by the client. And lastly, I think the most important benefit is, it provides certainty as to what you want to happen after you pass. It's one thing to mention it to, a passing family member, but we do need to have it written down, because that doesn't really mean much unless it's in this legally binding will. It doesn't stand for much to have, written something down on a scrap piece of paper or told someone, that you wanted them to have your whole estate, unless it's actually in the will that has been properly completed and signed off on. So what can you actually include in your will then? So who do you want to actually appoint as the executor? So this is the person that's actually going to administer your estate after you pass. So they're often known as, the executor, the administrator, or the testator. Now this is often in a couple situation. They'll often have the other person as their spouse as the executor. If they are to pass at the same time, or maybe they've passed before them, that they have an updated will, it could maybe be a child or something like that. That person does have to be over the age of 18. That appointment can be done in various ways. It could be a joint appointment that you're appointing, two of your adult children to do the role. Just note that it can't be any more than 4 people acting jointly as executors at one time. Obviously, we can have, successive people listed though if needed. As I mentioned before, if you are having children that are under the age of 18 at the time of drafting the will, then we would recommend having guardianship provisions in there. As Darren mentioned earlier, circumstances change. So maybe you don't have children at the time of drafting will, but it's something that's planned for the future. We can still include guardianship provisions for those unborn children to ensure that, once they're, entered the world, that we already have guardianship provisions taken care of, because obviously that's the last thing people are really thinking about once they've given birth to the child. Who do we actually want to inherit from your estate? So as I mentioned, these are known as the beneficiaries. Again, we always have backup layers with all these people that we're appointing. So, first beneficiary may be the spouse, and then it may be the children. If one of the children are to pass before the other, maybe their shares to go to the grandchildren who, they've just lost a parent, or it's up to you. They may just want it all to go to the surviving child of theirs. What do you actually want to happen to your body after you pass away? Do you want to have your cremation or would you rather just be buried? This can all be included in the will. And then, as I mentioned before, we'd specifically list any charities that we may be listing gifts to, or potentially you've got some specific gifts like a family heirloom or something like that that we want to list as a specific gift to go to someone. If there are any identifying unique circumstances, such as an estranged family member, we need to get these instructions from the client and make sure that it's dealt with properly in the will to avoid any disputes arising after you've passed away. So how do we go about then excluding a specific dependent from your estate plan if they are estranged? So you can leave your estate to whomever you like. It's obviously your prerogative to do so, but the court can award part of your estate to a spouse, child, or dependent. So as I mentioned before, if we do have a child that, we're estranged from, we haven't spoken to for 10, 15 years, we need to still acknowledge that child within our will and the reasons for the estrangement. This is obviously going to assist the court to make a final binding decision, which may be that child receives nothing. If that child is not dependent on you, hasn't been for, 15, 20 years, there's good, binding, valid reasons why they've been estranged from you, then the court's going to take that into careful consideration before making the decision. The court has to be satisfied, though, that there is a continued need for maintenance and support if they are going to choose to give money to a dependent. So it's clear, it needs to be clear and concise that line of dependence has been cut if the child has been estranged.
So I could probably say a couple of things there, Kayleigh, on those issues. Yeah, and these issues are becoming more and more prevalent, and we're certainly seeing a lot more of it in our office. And there's been a couple of clients this year where we've actually structured their assets a little differently in order to reduce the amount that's actually going into the estate. Because if we can pass the assets externally to the estate and do that with confidence, then that reduces the amount of money that can be contested come estate time. And if we can do that in a way too, that the client still has full control of the money, can use the money, can invest the money, can do whatever they sort of deem fit, well then all the better. And so that's another strategy we've been able to use with the investment bonds in terms of having an amount of money that will go to sort of Joe and Mary, and then an amount of money that we know is going to go there because that's where we want to go. And then the estate has the balance of the money, which might be the home or some bank accounts or whatever that might be. And then if the estate is contested, well, then we know already that Joe and Mary have been taken care of, and it's just what's left in the estate that is really being contested. So that can help.
Definitely, Darren. Yeah, certainly beneficial, I think, for many clients, because it is, as you said, it is becoming a growing issue. You know, as times go on, we're seeing more and more of it when we're drafting wills, and obviously yourself as well in your office in the financial planning space. So that's great to know. In terms of actually excluding your specific dependents from your estate plan, obviously, as you mentioned, you can do that outside of the estate, you know, by way of these investment bonds. But another way it obviously helps minimize the risk of someone contesting your will is to actually reduce your contestable assets, which I think is what you've spoken about a bit there. You know, you can transfer your assets while you're still alive. Often we'll have parties come to us saying, you know, I've got this property, I want this one to go to one son and this one to go to my daughter. You know, can we do that now while I'm actually still here and alive? Which, you know, of course we certainly can. You can hold your assets, property assets, in different ways. So, you know, joint tenants or tenants in common. Now, if you're holding them as joint tenants, that means that the share that you own as joint tenants will automatically go to the surviving party. So if one party is to pass away, often it's spouses that will hold as joint tenants, their shares automatically going to go to that surviving spouse. So it is important, obviously, you know, dealt with clients where they've, you know, gone and got divorces for whatever reason, they've left their spouse on the title, you know, haven't updated their will. If they were to pass away, it doesn't matter what the will said anyway, that property is automatically going to go to their former husband that they still own this property in, and that may not be their intention. So we do need to check, you know, what you've actually got property structures and assets owned in. The other option as well is actually creating a trust for the assets. So, you know, you can have different trusts set up, family trust, discretionary trust, or you know, you may even have it as a testamentary trust, which forms part of the will. Now, I'll go into actually structuring your estate for the targeted beneficiary distribution. So there are many different ways you can leave your assets. You know, I'm speaking, you know, in terms of your will. Darren's speaking a bit more about things outside of your will, like the investment bonds. But essentially, you can leave all your estate, less any cost of administration, you know, funeral and debts, known as the rest, and the residue of it to your spouse with your children to inherit it if the spouse was to pass away. You can leave any specific gifts you like, like I mentioned, family heirlooms, jewelry, things like that to a specific daughter, or maybe it's a niece or nephew, whoever you think needs to be given that particular family heirloom. You can also leave a life interest or right of residency to your spouse and then leave the estate to your children. We often find this one is in particular becoming a growing topic of interest for those blended families. So, they're wanting to look after their biological children. They've gone and, entered into maybe a marriage, and that other spouse have their own children as well, so they're still children. They want to make sure that their children are still looked after. So while they may have forked out the money for the property, they still want their life partner, who could be a second marriage, to have life interest in that actual property. But if they're to pass away, they don't want that property then going to their stepchildren. They want it going to their biological children. So the will would actually deal with that, and we would deal with a life interest in that regard. You can also leave different property to different beneficiaries, like I alluded to, obviously transferring property before you pass away, but obviously you can do so, in the will, leaving it as a specific gift. So, child one is getting, property in, Stanthorpe, and the second child's getting your property out at Gympie, whatever it may be. Now, in terms of structuring the estate for the targeted beneficiaries, you need to have a think about when might you want to leave a life interest or right to reside instead of actually gifting that property. So I mentioned before, blended families, often this is a wish to ensure that your children receive your share of the house, so your biological children, as opposed to going to your spouse's children who become your stepchildren. So by granting that right to reside, you can ensure that your spouse is still able to remain in the property, until there comes a time that they actually want to sell the property, whether that's to go into care or, maybe they at some point will pass away. So if you do leave the house to your spouse, you cannot control what they do with the house when you pass away. So by leaving the house to the spouse, as I mentioned and alluded to, if they pass away, that can go to their children, and your children are potentially going to miss out, or, whoever their next of kin may be. Now, some examples here. So we've just put a bit of a situation scenario up. So you helped your son Mark purchase his first house with his spouse, and to protect your interest, you are registered as a co-owner of that property. Now, you might have forked out, $100,000 towards Mark's first property purchase, essentially. But in the event that you pass away, you want to ensure that Mark actually receives the interest that you put into the property, and to ensure that this amount is accounted for in their final distribution of your estate. So to ensure that this is a fair distribution of your estate to all children, you need to make sure that this is specifically included in the will. That's a common one we see at the moment with rising house prices. Children can't afford to buy their own, first home. Mum and dad put in money, but this is a great way to actually protect that money and make sure that the actual biological child receives the interest of it. Now, what are some alternatives to super? I think that this one will be handing over to you for it, Darren.
Yeah, so further to what Kayleigh was just talking about, super obviously becomes a fairly significant estate asset for a lot of people. Once our children are over the age of 18, it's not that tax effective to leave it directly to them. In fact, it's probably not even that tax effective to leave it to your estate, but that's typically where it lands. And so it's prudent to sort of think about other options and alternatives to super where we can get similar sort of benefits. And particularly these days, now that there are more rules around superannuation and the use of it. And so we're going to talk about a couple of those things. But first of all, it's prudent to sort of acknowledge that super really is just a tax structure. And that's all it is. It's a form of tax structure with rules around it. And those rules become the trade-offs, if you like, in order to reap the benefits of the lower tax investments on the inside, and then once we're retired, getting some tax-free income out of it. So that's sort of how it works. Income is taxed at 15%, as I'm sure most of you know. Capital gains are taxed at between 10 and 15%, depending on what's happening with the assets on the inside. And of course, super is often taxed in the hands of the beneficiaries upon death. And that's clearly something that we would want to reduce. And then finally, just depending on the super vehicle that you're using, superannuation can house just about any sort of known asset, if you like. But look, I want to talk about time, because we talked earlier around, investing when we're young. And sometimes time is not on our side when it comes to super. If we want to access our money in 10 years or 15 years time, and we're 35 or 40 or 45 years of age, it may not actually work out that super's the right place to put our money, even if we are getting a bit of a tax hand along the way to do that. So we need to sort of consider that. And that leads to the next point. Well, can we replicate the tax structure outside of super? Because if we can do that and reduce those trade-offs of locking our money away, of not being able to get tax-free income until we retire and those sort of issues, well, then we're in a far better place. And as we alluded to earlier, we're actually able to do that with investment bonds as well. And there's a couple of points around how certain structured investment bonds operate that allows us to get the similar sort of tax benefits that super do. And some of the things that they're able to do is, first of all, use a revenue account. So for the accountants in the room, they'd understand what that is, but it's basically just where your capital and your capital transactions and your income transactions are all operating under one account. And that then means that we can offset capital losses against income earned, and that reduces tax significantly. And the other thing that a well-structured investment bond can do is parcel their trades, which means if they've been buying BHP shares for the last 10 years and then they want to sell some, they can choose which shares they wish to sell based on the tax consequences. So based on the cost base of each one of those shares or each one of those parcels. And that in turn obviously reduces the amount of tax paid on the inside of the investment. And then finally, of course, which is sort of known to everyone, the franking credits and being able to use the franking credits to the advantage of the underlying investment. So when a bond is structured in a way to be able to take advantage of all of those issues, we're then looking at 12 to 15% internal tax instead of 30%. And that's pretty much in line with what we're going to expect out of a superannuation investment, yet we haven't had to lock our money away. So while super is good for some parts of our dough, it's certainly good for our employers to put money into. There's a little bit of scope there for salary sacrifice for anyone earning sort of less than about $250,000 a year. But then, of course, on the other side of the coin, we've got to think about the Div 293s, and we'll talk a little bit later about Div 296 as well, and sort of managing those issues. So yes, we can definitely replicate that superannuation tax structure on the outside. And then which means we should be really thinking about, well, how do we build our wealth outside of super and outside of our property? Because that's what's really going to give us financial freedom a hell of a lot easier than a hell of a lot earlier than, say, age 60 or age 65. And ideally, with a mission of becoming less dependent on our employment income or on our business income, less dependent on waiting for superannuation to kick in and those sorts of things. Now, if we're going to sort of go down that track, well, access to our money early is going to be really important. And being able to access our money early without penalties becomes even more important. So if we're going to use an investment bond structure to do that, well, then we want to look at, well, how do we get the money into those investment bonds? What are the underlying investments we're going to use? How tax effective can we make that on the inside? And how frequently should we be putting money in? And how much should we be putting in? So we're not, like Grandma says, we don't want to put all our eggs in one basket, but we want to have an end game in mind. And that end game might be a certain amount of tax-free income. It might be a certain amount of lump sum available tax-free to pay out a mortgage, for example. So with the end game in mind, we can use these alternatives to super in order to invest ongoing through our sort of young and middle life, if you like, to try and get to a point earlier than retirement where we've actually got those options available. What's our next?
Perfect. Thanks for that, Darren. So obviously, yeah, you've spoken there about some alternatives to superannuation. Obviously, people are still going to, you know, have some money that's going into super. Like you said, there's still a requirement for their employer why they are employed to put money into their super. So I suppose for me, I'll talk about then how superannuation works in terms of your will. So basically, it's important to know that your superannuation is basically not covered by your will. So your will deal with all your assets that you own, except for your superannuation fund and potentially some of the other investment bonds that Darren may have set up. So we need to make sure that you've completed a binding death benefit nomination. So what is a binding death benefit nomination? Generally, it's a lapsing binding death nomination as well, and it's done through your superannuation company. So if you are with an industry super fund, highly recommend checking with them, do you have one of these in place, and if so, when does it expire? Obviously, if it has already expired, very important to make sure that you get that updated, simply just filling out the form to nominate your beneficiary. Now, with our estates, as you've seen in previous slides, you know, we can get a bit complex with who we're nominating as a beneficiary, whereas with your super fund form, they generally just want you to put one person down or two joint people potentially. So sometimes you can actually refer the nomination back to your estate by putting, you know, for as per your legal representative of your estate, which would mean the legal representative would be the executor, and the executor will then distribute your superannuation to the beneficiary in your will, which could be, you know, the spouse, but if they were to pass away, they'd then go to that next layer. So you need to ensure the person nominated is actually entitled to receive your superannuation as well, is an important thing. And generally, your siblings and parents are not eligible beneficiaries because they're not dependent on you. Your spouse, you know, children, they're generally people that are dependent on you. So they're the people that we should be nominating if we're just simply nominating one person as opposed to the legal representative of your estate. Now, sale of a business. This is a big one that, you know, pops up from time to time. We've got, you know, business sale contract is the blueprint for the transaction. It is essential that it's meticulously drafted to prevent future disputes and make sure that all parties are clear on the terms. So, you know, this is a way that most people often, you know, end up with a lump sum of money all at once. They're going to retire, they're going to sell off assets. So, you know, they're going to sell potentially the properties they own, they're going to sell their businesses, you know, look to start selling shares. And we need to make sure that that's done properly then to ensure that it's covered off on. So if you are looking to sell your business, you need to be assigning your rights under, you know, the lease. If you've got a lease in place, the landlord needs to be giving consent to that assignment. You know, there needs to be an actual deed of consent and assignment will need to be entered into, outlining the actual terms of the lease assignment. So we can't just, you know, assume that landlord's going to agree to, you know, who is going to be the incoming tenant. They need to do their own financial planning and understand, you know, can this person operate a business effectively, or am I going to end up as a landlord with a tenant who can't pay? You know, it could be a $250,000 lease per year and they're still locked in for the next 4 years. Now, I suppose in terms of business sales though, this is where a financial planner like Darren may come into play in terms of what will you do with that big lump sum of money once you've received the sale proceeds from the business sale. And I'll hand back over to you.
Look, it's fairly commonly known these days that we can use certain super strategies in order to reduce the capital gains tax on a business sale or on the sale of an active asset. However, it does need to be carefully managed because you'll find that there'll always be well, let me sort of wind the clock back a little bit. What we don't really want to be doing is exceeding our superannuation caps. And there's no, I guess, it's not a massive deal if they are exceeded at some levels. However, if we don't need to do it, well then why put ourselves in a position where we might have some top-up tax to pay or whatever. So what often happens when the CGT calculations are done for the sale of a business, there'll be a minimum amount that needs to be contributed to super in order to tick the CGT box and reduce the amount either to nil or to a meaningful amount or whatever that might be. So what we don't want to do is put much more than the minimum amount in that ticks the objectives on the CGT. So that typically then leaves an amount of money to do something else with. So we're using the superannuation strategies, and there's a number of them. We're going to use those to reduce the CGT to either nil or a meaningless amount. And then the balance of our funds, we want to use that to create, if this is, the objective of the client is probably going to be to create some income to replace the business income that was being earned by the money that's been sold, etc. So that's where we start to look at a combination of things. If you remember, we were talking about with the investment bonds previously, at a 10-year anniversary, they become fully tax paid, and so there's no additional tax required on withdrawals or on income streams. So with that in mind, we possibly want to have a combination of managed portfolios and investment bonds, and let one sort of take over the other over time. And what we find is that the managed investments will typically operate pretty well for the first few years in terms of generating income, and we might find that we can even withdraw some capital without too much CGT issue there, and particularly if we've got a husband and wife and we can split the taxes and those sorts of things. And then by about year 3 or 4 or 5, we find that the investment bond has started to tick along nicely, and that we can actually make some withdrawals there or create some income there, again, especially if it's jointly owned, and we're getting the 30% offsets on the earnings, if you remember, and the capital coming out as tax-free. So the investment bond would start to take over the income production after about sort of year 3, 4 or 5. And if we've sold our business prior to the age of 60, say we've sold our business at age 50 or 55, we don't have access to our super anyway in order to generate the income from the money that went in from our business sale. And so being able to hold some money out and run these other strategies allows us to generate some income, I guess, external to any other work or business opportunities we might be taking elsewhere. And so therein lies your sort of early retirement opportunities, if you like. I've sort of mentioned here, look, why super income is not so good in middle and later retirement. I'm not going to go too much into that because of time, but effectively the way superannuation income streams work, we don't want too much in there because we end up just pulling our money out of tax-free investment environment and it lands in cash. So if we've got some other vehicles going alongside our super prior to retirement, then those vehicles could continue through retirement and we can channel money into those in later years of life as well, which can be very beneficial for the longevity of your money, the longevity of your assets, and of course the sustainability of your estate, and having your estate worth as much upon your passing as what it would have been, when you were still fit, healthy, and alive. How do we determine the optimum mix of assets going into super, into bonds, into managed accounts and the like? Well, really, that just takes a bit of modelling and a bit of forethought, and that's where you should, contact your chosen professional, whether it be a firm like ours or if you already have someone who you're talking to. They're the questions that they should be able to answer for you and model those things out so that you have a staged plan post-business sale where you're creating income, you're creating some capital growth, and then you've got your retirement assets kicking in down the track. What's next, Kayleigh?
Awesome. Thanks very much, Darren. Important to know because, a lot of people come into lump sum of money, whether it be from an inheritance, a business sale, selling off their property portfolio, and they don't know what to do with that money. So it gives them some guidance. Yep. Now, obviously, if they are looking to, sell properties, to their son or daughter prior to actually passing away, so it's not done through the will. Sometimes there's what's called transfer duty that could be inherited. It may need to be payable prior if it's done. However, no transfer duty will be payable if the transfer is done in accordance with the actual terms of the will or the laws of intestacy. So no duty will be payable if the transfer results from the death of a joint tenant as well. So again, as I mentioned before, that won't come into, the will won't come into play when there's a joint tenancy arrangement. The property will just automatically transfer to the surviving joint tenant, which is often the spouse. Now, there is also no inheritance tax that's applied in Australia if you inherit a large sum of money from the testator of a will. And the last thing to note as well is how to determine the optimum mix of the assets and strategies, which is what, Darren's gone through previously. So I don't think we need to rehash on that one in too much detail. Now, duties and inherited properties in Queensland. So duty may be payable though if the transfer is not in accordance with the will or intestacy. So for example, if you own 2 blocks of land, one was worth $100,000, we'll call this block A, the other's worth $300,000, known as block B, and you died without a will and had 2 children, no spouse at the time of your death. Basically, the laws of intestacy will come into play here, and your children, you've decided that one will inherit block A and the other will receive block B. Now, as the children receiving block B, which is worth 3 times the amount basically, so significantly greater share of the estate, duty is going to be payable because laws of intestacy should say that each child should receive an equal amount. So, it's $400,000 in the property pool there, they should be receiving $200,000 each of that. So unless there are ways to basically get around this, which would be basically that they couldn't do this. They would need to sell off those properties and each split a share of the profits, or otherwise, child 1 could own block A, but child 1 would also need to own, 2/3 or half of the interest in that second block as well to make it up to the $400,000 value. So if you did have a will in place though, where you actually specified the distribution to be the exact same as the example above, the transaction would be fully reduced in terms of the transfer duty. There would be no transfer duty payable on that transaction just because you had that will in place. So obviously another benefit of actually having that will in place to avoid any transfer duty implications, for children, if specifically if you are, giving unequal shares in property, which the children may want. One may already be living in block A and the second child could already be living in block B. We do appreciate you taking the time out of your day to join us and listen to a little bit more. By all means, welcome to email either Darren or myself. Our contact details are below, or give us a call, and happy to have a obligation-free consultation with you to discuss your specific needs. Hopefully a few of you have been able to take a few tips like that away and put them into place. Otherwise, feel free to have a chat to us about it a bit more. But I think we'll end the session here, and you can reach out to us. You've got our contact details, but I appreciate you listening. Thank you for joining us as well, Darren.
Thanks, Kayleigh. Thank you, everyone. See you soon.
Thank you for tuning in to another episode of Property Powered Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at MB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.